Hello, Cybersecurity National Security Law class. Welcome to Class 5. And in this class, we're going to start talking about internet surveillance. And obviously, this is a very hot topic. It's been in the news, and it's something that continues to be debated. And in many ways, I think it's really the heart of what we're talking about in this module. What I first want to do is point out to you the range of existing legal authorities for gathering electronic information. And this chart puts a number of these together. I didn't ask you to read all of these statutes just because we don't really have enough time to read through all of them. But the chart here summarizes these different authorities. So the basic principle, of course, is the constitutional principle that personal information need not be disclosed to the government without some reason, and in particular in the criminal context without some kind of showing of probable cause. So the first list on this chart is the Wiretap Statute. So when you think of a wiretap, you probably think of the kind of classic old gangster movies where the feds are literally tapping into the phone line, and indeed that is where the notion of a wiretap comes from. And the statute originally is created to deal with that, but the statute is much broader than just that. So essentially when you think of a wiretap, you want to think of the contents of communications in transit. So real-time in-transit contents. And essentially what the wiretap statute requires really goes beyond the minimal requirements of the Constitution and requires something that you might consider a super warrant. That is, it requires a showing of probable cause, which is what the Constitution requires, and that normal investigative procedures have failed or will likely fail or are too dangerous. So there's some recognition in the Wiretap Statute by Congress that intercepting communications in transit is even more serious than other kinds of intrusions on privacy that would require an ordinary warrant. Then we have the Electronic Communications Privacy Act, and what the ECPA does is set out procedures for the government to obtain either information that is in storage, electronic storage, or information that is simply identity and billing records. And the ECPA divides up the content of communications from what we might consider header information, which is information about the transit or identity of who is receiving certain communications. So if you notice here, if the information is in storage 180 days or less, the government is required to get a warrant showing probable cause. If the information is in storage longer, more than 180 days, the government is required either to obtain a warrant showing probable cause or a court order with advance notice to the subscriber, in other words, to the person whose information it is, showing why the information supposedly is required. Now, why the difference there? Well, if you're giving notice to the subscriber, then the subscriber can contest that. Very similar to, for example, a subpoena in a civil action. You certainly can subpoena the contents of records in a civil action from a third party, but the person whose information it is would have an opportunity to move to quash the subpoena. And so a warrant, of course, is an ex parte application. There's ordinarily no opportunity to contest the warrant. You only can later on contest the introduction of that evidence if you believe the warrant was improperly issued. The pen register and trap and trace statute relates to obtaining non-content routing information in real time. So the ECPA is information that is in storage. Wiretap, the contents of information in real time. Pen register, trap and trace is non-content routing information in real time. And again, think of the old gangster movies with the feds kind of tapping into the wire. You could actually put a physical device on a phone, and that physical device could trace all of the phone numbers that were dialed out of or received into that telephone. That's pen, register, and trap and trace, and now we kind of transpose that into our current electronic world. So notice that for the pen, register, trap, and trace, you don't require a warrant, you only require a court order, and you have to make a showing that is something less than probable cause. In other words, that the information is likely to be relevant to an ongoing investigation. Notice also under the ECPA, you can obtain simply subscriber information. That is, who's the identity of a subscriber and what is their associated username, with a court order on a showing much less than a warrant that it's relevant and material to an ongoing investigation. There does not, in that instance, have to be notice to the subscriber. So moving down this list, we have NSLs, or National Security Letters. This is a specific federal statute that allows the FBI to obtain subscriber information and toll and billing records. And toll and billing, that sounds like telephone, that's right. But again, this also applies in the electronic age to electronic communications. And again, all it requires is for the FBI, they don't even need to obtain a court order, they simply need to issue the letter on a statement that the information is relevant to an ongoing investigation to protect against terrorism or clandestine intelligence activities. There does not need to be any disclosure to the subscriber, but there is an opportunity for the holder of the information, say an internet service provider, to challenge the letter. These letters, along with the expanded FISA procedures under the Patriot Act, became quite controversial after 9/11. And then we get into the Fisa Statute, the Foreign Intelligence Surveillance Act. And we'll talk in some depth. You can see here in the slide the kind of summary of those provisions, but we're going to talk in just a moment in some depth about what those provisions are.